What is Katarungang Pambarangay? Katarungang Pambarangay is a system of dispute resolution instituted in all barangays in the Philippines that seeks to promote, among others, the speedy administration of justice by providing all avenues to an amicable settlement, thereby considerably reducing the dockets in our courts of justice. Number 2. How was Katarungang Pambarangay introduced into our justice system? The first abstract conception of the Katarungang Pambarangay law started in 1976 when Supreme Court Justice Fred Ruiz Castro proposed the innovative idea of settling disputes through neighborhood paralegal committee. The abstract conception of the law first saw a ray of hope for a possible passage of a law when Presidential Decree 1293 was promulgated on January 27, 1978. It created a presidential commission tasked with the duty of studying the feasibility of instituting a system of settling disputes among the members in the barangay without going to courts. 3. What was the first law that institutionalized Katarungang Pambarangay? Presidential Decree No. 1508 in 1978 was the first KP law that institutionalized Katarungang Pambarangay. It was promulgated by then President Ferdinand Marcos. With the passage of Presidential Decree No. 1508 in 1978, the law took effect on December 30, 1978, and this was the law that organized, established, and institutionalized a formal system of amicable settlement of disputes at the barangay level. Number 4. What was the real intent of the passage of PD 1508? Although PD number 1508 was the first law to organize, establish, and institutionalize the Katarungang Pambarangay, its real intent was to give full recognition to the historical fact that peaceful settlement of disputes among the family and barangay members without going to the courts is a time-honored tradition in the Philippines and is at the root of a Filipino culture. 5. Has PD 1508 been amended or repealed? Yes. 14 years later, PD number 1508 was repealed by RA 7160, otherwise known as the Local Government Code of 1991. In the repealing law, the KP law was incorporated as part of the codified laws on local government, sections 399 to 422, Chapter 7 of RA 7160 are the relevant sections on Katarungang Pambarangay. 6. What are the purposes and objectives of the Katarungang Pambarangay? The essence of a barangay justice is a peaceful and harmonious resolution of conflicts within the barangay instead of adversarial proceedings in the courts. Peaceful settlement of disputes among the family and barangay members without going to the courts is a time-honored tradition in the Philippines and is at the root of a Filipino culture. KP recognizes the traditional modes of dispute resolution born out of time-honored traditions of pakikisama, community spirit; utang na loob, debt of gratitude, kinship. KP helps reduce the number of indiscriminate filing of cases that leads to congestion of court dockets by compelling the parties to settle their conflicts through the intervention of the barangay. The animosity generated by a protracted court litigation, which is a disruptive factor toward unity and cooperation, is avoided. It is believed, however, that the KP law can be used to achieve higher societal goals, such as good citizenship and strong communities beyond its originally intended purpose of decongesting the court dockets. The KP structure, composition, constitution, and functions of the lupong tagapamayapa pangkat ng tagapagsundo and legal advisors. 1. What body is tasked by law to administer the Katarungang Pambarangay? The lupong tagapamayapa, it is the body organized in every barangay composed of the barangay captain as chairman and not less than 10 nor more than 20 members, from which the members of every pangkat shall be chosen. Although the lupon as a whole does not facilitate mediation or conciliation proceedings, the members of the pangkat, which conducts mediation or conciliation sessions, are chosen from the members of the lupon. The lupon may be assisted by the provincial legal officer, city legal officer, municipal legal officer, and or public prosecutor on matters involving questions of law necessary in the administration of the Katarungang Pambarangay. Second, what are the three components of the Katarungang Pambarangay? The Katarungang Pambarangay is said to have three components: A. The lupong tagapamayapa, B. The pangkat ng tagapagsundo, and C. The legal advisors. 3. What is the relationship among the three components? The following diagram illustrates the relationship of the three components of the Katarungang Pambarangay. Lupong tagapamayapa, Peace-Making Council. Pangkat ng tagapagsundo, Conciliation Panel. Legal advisors. Although the three components are considered as separate and distinct, and so far as their roles and functions are concerned, the three components interact and relate to each other as they perform their separate roles and functions. 4. What is the role of the lupong tagapamayapa? The lupon is the peacemaking council in the barangay. 5. What is its composition? The lupon is created in each barangay and is composed of A. The punong barangay as chairman, and 10 to 20 members appointed by the punong barangay. 6. What are the qualifications and disqualifications of a lupon member? For a person to become a lupon member, he should possess all of the following qualifications and none of the disqualifications. Qualifications of lupon member. 1. Any person who is actually residing or working in the barangay. 2. Not otherwise expressly disqualified by law. And 3. Possessing integrity, impartiality, independence of mind, sense of fairness, and reputation for probity. Disqualifications. The following persons are disqualified to become members of the lupon. 1. Persons convicted of crime with an accessory penalty disqualification from holding public office. 2. Minors. 3. Members of the armed forces who are still in active service. 4. Government employees. And 5. Elected government official. 7. How is the lupon formed? Within 15 days from the start of his term, the punong barangay prepares a notice to constitute the lupon, which shall include the names of the proposed members who have expressed their willingness to serve. Such notice shall be posted in 3 conspicuous places in the barangay continuously for a period of not less than 3 weeks. The punong barangay, taking into consideration any opposition to the proposed appointment of any recommendations as may have been made within the period of posting, shall within 10 days thereafter appoint as members those whom he determines to be suitable therefor. The list of appointed members shall be posted in 3 conspicuous places in the barangay for the entire duration of their term of office. Upon appointment, each lupon member shall take an oath of office before the punong barangay. The lupon formation process is summarized in the following diagram. The lupon formation process: notice, posting, appointment, oath of office. 8. What are the forms used in the lupon formation process? The following forms are used. Take a look at it. 9. What is the lupon member's term of office? A lupon member holds office until a new lupon is constituted on the 3rd year following his appointment, unless sooner terminated by resignation, transfer of residence or place of work, or withdrawal of appointment by the punong barangay with concurrence of the majority of all the members of the lupon. 10. Can a lupon member's appointment be withdrawn? Yes. A lupon member's appointment can be withdrawn by the Punong Barangay after due hearing and with the concurrence of a majority of all the Lupon Tagapamayapa members. A Lupon member's appointment may be withdrawn on the grounds of incapacity to discharge the duties of his office or unsuitability. 11. What form is used for the withdrawal of a Lupon member's appointment? No, the members of the Lupon conforming to the withdrawal must personally affix their signatures or thumb marks on the pertinent spaces above. The withdrawal must be confirmed by more than one half of the total number of members of the Lupon, including the Punong Barangay and the member concerned. 12. In case of vacancies in the Lupon, how is this filed? Should a vacancy occur in the Lupon for any cause, the Punong Barangay immediately appoints a qualified person who shall hold office for the unexpired portion of the term. 13. What are the functions of the Lupon? Exercise administrative supervision over the conciliation panels. Meet regularly once a month to provide a forum for exchange of ideas among its members and the public on matters relevant to the amicable settlement of disputes, and to enable various conciliation panel members to share with one another their observations and experiences in effecting speedy resolution disputes. And 3. Exercise such other powers and perform such other duties and functions as may be prescribed by law or ordinance. 14. Who serves as the secretary of the Lupon? The barangay secretary concurrently serves as the secretary of the Lupon. 15. What are the functions of the Lupon secretary? The following are secretary's functions: record the results of mediation proceedings before the Punong Barangay, submit a report of the mediation proceedings to the proper city or municipal courts, and finally receive and keep the records of proceedings submitted to him by the various conciliation panels. 16. What is pangkat ng tagapagsundo? Pangkat ng tagapagsundo is the conciliation panel that hears each dispute brought before the Lupon. 17. What is its composition? The pangkat ng tagapagsundo is composed of 3 members who are chosen by the parties to the dispute from the list of members of the Lupon. 18. How is the membership of the pangkat determined if the parties fail to agree on its membership? Should the parties fail to agree on the pangkat membership, the same shall be determined by the lots drawn by the Lupon chairman. 19. In the event that there are vacancies in the pangkat, how is this filled? Any vacancy in the pangkat shall be chosen by the parties to the dispute from among the other members of the Lupon. Should the parties fail to agree on a common choice, the vacancy shall be filled by lots drawn by the Lupon chairman. 20. Who are the officers of the pangkat? What are their functions? The 3 members constituting the pangkat elect from among themselves the chairman and the secretary. Chairman presides over meetings or hearings before the pangkat. Secretary prepares the minutes of the pangkat proceedings and issues notices to the parties concerned, also tasked with the issuance of the certified true copies of any public record in his custody that is not by law otherwise declared confidential. 21. If the Lupon encounters a difficult question of law, to whom may the Lupon consult? On matters involving questions of law necessary in the administration of the KP, the following shall render legal advice: Provincial Legal Officer, City Legal Officer, Municipal Legal Officer, and Public Prosecutor. Substantive aspects of Katarungang Pambarangay: subject matter, venue, and jurisdiction. 1. What disputes may be brought by amicable settlement before the Katarungang Pambarangay? Disputes between or among the parties who are actually residing in the same city or municipality may be brought for amicable settlement before the Lupon. 2. Are there cases which the Lupon does not have authority to hear? Yes. The Lupon shall have no authority in the following cases: A. Where one party is the government or any subdivision or instrumentality thereof. B. Where one party is a public officer or employee and the dispute relate to the performance of his official functions. C. Offenses punishable by imprisonment exceeding 1 year or a fine exceeding 5,000 pesos. D. Offenses where there is no private offended party. E. Where the dispute involves real properties located in different cities or municipalities unless the parties there to agree to submit their differences to amicable settlement by an appropriate lupon. F. Dispute involving parties who actually resides in barangay or different cities or municipalities except where such barangay units adjoin each other and the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. G. Such other classes of disputes which the President may determine in the interest of justice or upon the recommendation of the Secretary of Justice. 3. Can courts refer some cases to the lupon for mediation or conciliation even if the said cases are already outside of the lupon's authority? The court in which non-criminal cases not falling within the authority of the lupon are filed may motu proprio refer the case to the lupon concerned for amicable settlement at any time before trial. However, where the civil case is covered by the rule and summary proceeding, its referral to the lupon, which has no authority over the case, is saliently an unsound exercise of discretion. 4. What cases do not require barangay conciliation as a prerequisite for filing in court? Supreme Court Administrative Circular 1493 provides for the following additional cases which do not require the mandatory conciliation or mediation before the lupon. 1. Disputes where urgent legal action is necessary to prevent injustice from being committed or further continued, specifically the following. A. Criminal cases where accused is under police custody or detention. See Section 412, Letter B, Revised Katarungang Pambarangay Law. Letter B. Petitions for habeas corpus by a person illegally deprived of his rightful custody over another or a person illegally deprived of or on acting in his behalf. Letter C. Actions coupled with provisional remedies such as preliminary injunction, attachment, delivery of personal property and support during the pendency of the action, and finally, actions which may be barred by the statute of limitations. Number 2. Any class of disputes which the President may determine in the interest of justice or upon the recommendation of the Secretary of Justice. Number 3. Where the dispute arises from the Comprehensive Agrarian Reform Law, CARL, Sections 46 and 47, RA 6657. Number 4. Labor disputes or controversies arising from employer-employee relations, Montoya versus Escayo et al. Labor Code as amended, which grants original and exclusive jurisdiction over conciliation and mediation of disputes, grievances, or problems to certain offices of the Department of Labor and Employment. Number 5. Actions to annul judgment upon a compromise which may be filed directly in court, Sanchez versus Tupas. 5. What are the common types of case brought before the lupon? Based on the 10-year report of the DILG on Katarungang Pambarangay Law, the types of cases brought before the lupon are as follows. Letter A. Criminal cases, physical injuries, slander, threats, robbery, theft, drug abuse, damage to property, estafa, trespassing, coercion, and unjust vexation. Civil cases are ejectment, family or marital problems, collections of debts or rentals, breach of contract, damages, demand for specific performance of obligation arising from contracts. 6. What is the difference between the term venue and jurisdiction? Are they synonymous? The two terms are not synonymous to each other. Venue is the place where an action is filed, heard, and tried, while jurisdiction is the power to decide or hear a particular case. 7. If a dispute is submitted to the lupon of a certain barangay but the same is supposed to be heard by the lupon of another barangay, when should an objection to the venue be raised? Objection to venue must be raised in the mediation proceedings before the punong barangay. Otherwise, the same is deemed waived. Moreover, such objection must not be made before the pangkat. 8. What are the rules to determine the proper venue of dispute? Types of dispute between persons actually residing in the same barangay. Venue shall be brought before the lupon of said barangay. Type of dispute involving actual residents of different barangays within the same city or municipality. Venue shall be brought in the barangay where the respondent or any of the respondents actually resides at the election of the complainant. Type of dispute involving real property or any interest therein. Venue shall be brought in the barangay where the real property or the larger portion thereof is situated. Type of dispute arising at the workplace where the contending parties are employed or at the institution where such parties are enrolled for study. Venue shall be brought in the barangay where such workplace or institution is located. 9. The law provides that disputes between or among the parties who are actually residing in the same city or municipality may be brought for amicable settlement before the lupon. What types of residence is required for purposes of determining the proper venue? PD 1508 requires that disputants must be members of the barangays who are actually residing therein. Residence alone without membership in said barangays would not be an accurate and reliable criterion. Mere membership in a barangay without actual residence therein should not suffice, since absentee membership would not subserve the avowed purpose of PD 1508 for lack of common bond and sense of belongingness to a particular identified group. Spouses Beher versus CA and Spouses Samar, GR 79404. 10. To whom should the requirement of actual residence and membership apply? The statutory requirement of actual residency and membership in the barangay is applicable to the real party in interest, not to the attorney in fact. Where parties are not actual residents in the same city or municipality or adjoining barangays, there is no requirement for them to submit their dispute to the lupon, even if both of their attorneys in fact are actual residents of the same barangay. Pascual versus Pascual. 11. The parties reside in barangays of different cities or municipalities, but the real property subject matter of the case is located in one and the same barangay. For example, Barangay Tubuan, Sual, Pangasinan. Does the lupon of Barangay Tubuan have jurisdiction or authority over the dispute? Lupon has no authority over the case. The lupon shall have no jurisdiction over disputes where the parties are not actual residents of the same city or municipality, except where the barangays in which they actually reside adjoin each other. In such a situation, where the lupon is without jurisdiction of the controversy because the parties are not actual residents of the same city or municipality or of adjoining barangays, the nature of the controversy is of no moment, whether or not affecting real property or interest therein, located in the same city or municipality. Agbayani et al. Versus Judge Belen. The KP process. How is the entire process in Katarungang Pambarangay done? Assuming the parties are able to reach an amicable settlement of their dispute, the Katarungang Pambarangay generally follows the following process. Complainant mediation before the lupon chairman, and if they reach an agreement, amicable settlement is reached, they go to execution. Otherwise, conciliation through the pangkat. After that, amicable settlement is reached, they go to execution. 2. Who may initiate proceeding? How is this done? Any person who has cause of action against another involving any matter within the authority of the Lupon may complain, orally or in writing, to the Barangay Lupon chairman upon payment of the appropriate filing fee. 3. What are the methods of alternative dispute resolution or ADR, which are commonly used in Katarungang Pambarangay? The following ADR methods are commonly used: mediation, 2. Conciliation, and 3. Arbitration. 4. What is meant by mediation? This means a voluntary process in which a mediator, selected by the disputing parties, facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. Section 3, letter Q of RA 9285. Number 5. What does conciliation mean? This is a process in which an impartial person acts as an intermediary to open communication between parties to resolve their dispute. 6. What is the meaning of arbitration? This is a voluntary dispute resolution process in which one or more arbitrators, appointed in accordance with the agreement of the parties or rules promulgated pursuant to law, resolve a dispute by rendering an award. Section 3, letter D, RA 9285. 7. What are the 2 stages of Katarungang Pambarangay process? The 2 stages are: 1. Mediation before the Lupon chairman, and 2. Conciliation before the Pangkat. Number 8. What are the steps and principles followed in the mediation before the Lupon chairman? Upon receipt of the complaint, the Lupon chairman shall summon the respondent with notice to the complainant for them and their witnesses to appear before him for mediation of their conflicting interests within the next working day. The respondent may submit his answer, and he may interpose his counterclaim. Hearing is done informally. Next, technical rules of evidence are not resorted. Next, settlement must be reduced into writing, signed by the complainant and respondent, and attested by the barangay chairman. And finally, if the mediation efforts of the Lupon chairman fail within 15 days from the first meeting of the parties before him, he shall forthwith set a date for the constitution of the Pangkat. 10. If the dispute is not settled before the Lupon chairman, what will be the next step? The dispute shall be referred to the Pangkat ng Tagapagsundo for conciliation. 11. How will the Pangkat be constituted? The Pangkat shall be constituted by allowing the parties to choose from among the Lupon membership the 3 members of the Pangkat. They shall also choose a 4th person as alternate member of the Pangkat. Should the parties fail to agree on the composition of the Pangkat, they shall, in the presence of the barangay captain or secretary, make the selection in the following manner. In case there is more than one complainant or respondent to the dispute, each side shall choose from among themselves one who shall be its representative to the selection process. Each side to the dispute shall then draw by lot to determine which one of them shall be first to strike out a name from the list of Lupon membership. Each side shall thereafter alternately strike out names from the said list until only 4 shall remain. The barangay captain shall draw by lot from among the 4 names one who shall be the alternate member of the Pangkat. 12. When shall the Pangkat convene? The Pangkat shall convene not later than 3 days from its constitution, on the day and hour set by the Lupon chairman, to hear both parties and their witnesses, simplify issues, and explore all possibilities for amicable settlement. 13. What shall the Pangkat do during its meeting with the parties? The Pangkat shall meet to hear both parties, explore possibilities for amicable settlement within 15 days, which can be extended for another 15 days in a meritorious case, and issue subpoena of witnesses whenever necessary. 15. Are these cases when conciliation before the pangkat is dispensed with? The convening of the pangkat is unnecessary when a party fails to appear without justifiable reason during the barangay conciliation and mediation or arbitration. In this case, what the lupon should do is to issue a certification to file action. Alinsugan versus Kagampang. 16. What are the grounds for disqualification of a pangkat member? Relationship, bias, interest, or any other similar grounds. 17. Who can move to disqualify a pangkat member? Any party to the case. 18. How is a motion to disqualify a pangkat member resolved? By affirmative vote of the majority of the pangkat whose decision shall be final. 19. Does the lupon and pangkat have the power of contempt? Both the lupon and pangkat do not have power to directly punish the parties and their witnesses for contempt. Reason: power of contempt is an inherent attribute of the court. The lupon and the pangkat, however, may file an application to cite any party or his witness who willfully and deliberately fails or refuses to appear without justifiable ground, despite notice, for indirect contempt before the court. 20. What is the punishment of a person who is cited for indirect contempt? Fine not exceeding 5,000 or imprisonment not exceeding 1 month or both. 21. What is the rule when it comes to appearance of parties before the KP? Parties must appear in person without the assistance of counsel or representative except for minors and incompetents, who may be assisted by their next of kin who are not lawyers. Rationale: to enable the lupon to secure first-hand and direct information about the facts and issues. The participation of lawyers, with their tendency to use their analytical skills and legal knowledge, tend to prolong instead of expedite settlement of the case. 22. If a party does not appear before the lupon, what are the consequences for his non-appearance? On the part of the complainant, complaint may be dismissed. Dismissal shall bar the complainant from seeking judicial recourse for the same cause of action as that dismissed. On the part of the respondent, any counterclaim arising from or is necessarily connected with the complainant's action may be dismissed. Dismissal shall be a bar to the respondent from filing such counterclaim in court. Non-appearance shall likewise be a sufficient basis for the issuance of a certification to file action. And finally, willful failure or refusal to appear may subject the party or witness to punishment for contempt. 23. What processes are accorded to either the complainant or respondent if he fails to appear? A hearing shall be conducted so that the party who failed to attend the previous hearing will be required to give an explanation of his absence and of why sanctions enumerated in the foregoing paragraphs will not be imposed. 24. What is the nature of the Katarungang Pambarangay proceedings? KP proceedings are public and informal. However, the lupon chairman or the pangkat chairman, as the case may be, may motu proprio or upon request of a party exclude the public from the proceedings in the interest of privacy, decency, or public morals. 25. If the parties agree to an amicable settlement of their dispute, what are the formal requirements for the amicable settlement? The amicable settlement must be in writing, in a language or dialect known to the parties, signed by them, and attested by the lupon chairman. 26. Are there certain issues which cannot be the subject matter of a compromise agreement? Yes, as a rule. The parties can agree on whatever clause, agreement, or stipulation provided it is not contrary to law, morals, good customs, public order, and public policy. Here, the following issues are not subject to compromise: civil status of persons, validity of a marriage or a legal separation, any ground for legal separation, future support, and jurisdiction of courts. 27. What is a certificate to file action? This is the document issued by the Lupon Secretary or the Pangkat Secretary and attested by the Punong Barangay or Pangkat Chairman. 28. When is the certificate issued? This is issued when no settlement was agreed upon between the disputing parties. There is such a settlement, but later repudiated by the complainant because his consent to the agreement was obtained through fraud, violence, or intimidation. When the respondent failed to appear or refused to attend a hearing without a valid reason, the issuance of a certificate to file action is a ministerial duty. 29. What are the requirements before certificates to file action, to bar counterclaim are issued? A hearing should be set and conducted by the Punong Barangay or Pangkat Chairman to give the absent party an opportunity to explain the reasons for his absence. When the Punong Barangay determines that such failure to attend was intentional and with no good reason, then he shall direct the Secretary to issue the applicable and proper certificates. 30. It has been said that another method of dispute resolution method used in Katarungang Pambarangay is arbitration. What is meant by that? Arbitration means a voluntary dispute resolution process in which one or more arbitrators appointed in accordance with agreement of the parties or rules promulgated pursuant to the law resolve a dispute by rendering an award. 31. When will arbitration come about? At any stage of the proceedings, the parties may agree in writing that they shall abide by the arbitration award of the Lupon Chairman or the Pangkat. The agreement to arbitrate may be repudiated within 5 days from the date thereof for the same grounds and in accordance with the procedure herein prescribed. 32. What are the steps that are usually followed in arbitration? Step 1. The arbiter orders the Secretary to call the case. Step 2. The Secretary identifies and enters into record all appearances from both parties. Step 3. The arbiter calls the complainant to present his or her evidence. A person he is to give testimony before an arbitration proceedings shall be sworn to an oath to tell the truth and nothing but the truth. And step 4. When a witness is necessary, he or she is summoned to testify before the proceedings. Step 5. The arbiter calls the respondent to present his or her defense, present evidences and witnesses in the manner afforded to the complainant. Step 6. After the parties have completed their presentation, the case is closed for resolution or decision. At this stage, the adjudicative trial is completed. 33. In arbitration, what is the period of time given to arbitrators to hand down the decision or award? The decision or award must be handed down to the parties within 15 days, but not later than 6 days from the date of the last hearing. Within 5 days thereafter, the Secretary shall furnish a copy of the arbitration award to the parties, keep a file at the Lupon office, and furnish a copy to the city or municipal court. 34. If a party is aggrieved of the decision or award, what must he do? The parties are given 10 days to nullify the decision. After 10 days, the decision becomes final and executory. 35. How is amicable settlement or arbitration award or decision executed? There are 2 tiers in the execution process. First, execution is done by Lupon, and then execution by the appropriate city or municipal court. Execution by the Lupon may be done within 6 months from the date of settlement. After the lapse of 6 months from the date of settlement, execution is done by action in the appropriate city or municipal court. 36. What is the timeline of the whole execution process? 6 months. Execution by the Lupon, date of settlement, execution by court action. The timeline of 6 months should be computed from the date of settlement. Exception: if the obligation to be enforced is due and demandable on a date other than the date of the settlement, the 6-month period should be counted from the date the obligation becomes due and demandable. 37. What are some examples of counting the 6-month period? 1. A promised to settle his debt on the date of signing the amicable settlement. Date of settlement is May 8, 2012. Last day for execution by the Lupon is November 8, 2012. Number 2. A promised to settle his debt on July 1, 2012. Date of settlement is May 8, 2012. Last day for execution by the Lupon is January 1, 2013. 38. What is the procedure of execution by the Lupon? Party interested in the execution files a motion for execution with the Punong Barangay. Punong Barangay conducts hearing on the date assigned by the movant. Date shall not be later than 5 days from the filing of motion. During the hearing, the Punong Barangay shall ascertain the facts for the non-compliance of the settlement and strongly encourage the party obliged to comply with settlement. After the lapse of 5 days, with no voluntary compliance, the Punong Barangay shall issue a notice of execution. 39. What are the different modes of execution? Payment of money. The actual execution may be in the form of money, but in case of failure to comply voluntarily with the settlement, the Punong Barangay shall take possession of sufficient personal property of the party obliged. The property can be sold and the proceeds applied to the amount. Possession of property. If the property is located in the barangay, the Punong Barangay shall oust from the property the person against whom the settlement or arbitration award is rendered. If the property is outside the barangay but within the same city or municipality, the Punong Barangay shall authorize other Punong Barangay to take possession and act in accordance with the preceding paragraph. Conveyance of land, delivery of deeds or other documents, or performance of any specific act. The Punong Barangay may direct the secretary to perform the act at the cost of the disobedient party. Costs will be charged to the disobedient party. 40. How is execution by court action done? By filing a motion for the issuance of a writ of execution by the party. 41. What is the possible action of the court on the motion? The court may grant by issuing a writ of execution and ordering the sheriff to obtain compliance of judgment from the other party. Issuance of writ is ministerial duty of the court. 42. Can an amicable settlement or arbitral decision or award be repudiated? Yes. And the party to the dispute may, within 10 days from the date of settlement, repudiate the same by filing the Lupon chairman a statement to that effect, sworn to before him, where the consent is vitiated by fraud, violence, or intimidation. Such repudiation shall be sufficient basis for the issuance of the certification for filing a complaint. Question 1. What are the rules on venue as provided under the Katarungang Pambarangay? A. Where the parties reside in the same barangay, the dispute shall be brought for settlement in said barangay. B. Where the parties reside in different barangays in the same city or municipality, the dispute shall be settled in the barangay where the respondent or any of the respondents actually reside at the choice of the complainant. Letter C. Dispute involving real property shall be brought for settlement in the barangay where the real property or any part thereof is situated. Letter D. Any objection relating to venue shall be raised before the barangay captain during the mediation proceedings before him. Failure to do so shall be deemed a waiver of such objection. And E. Any legal question relating to venue may be raised to the Minister of Justice, whose ruling thereon shall be binding upon the parties involved. The proceedings shall nevertheless continue pending resolution of such question. Sub-question. Mario, a resident of Acop, Tublay, Benguet, filed a complaint against Johnny, a resident of Cruz, La Trinidad, Benguet. The Punong Barangay of Cruz refused to accept the complaint of Mario. Will the Punong Barangay of Cruz be held administratively liable for refusing to accept the complaint? Explain. The answer is letter B. Where the parties reside in different barangays in the same city or municipality, the dispute shall be settled in the barangay where the respondent or any of the respondents actually resides, at the choice of the complainant. The complainant is Mario. Johnny is the respondent, and Cruz is the resident of Johnny. Number 2 says that the dispute shall be settled in the barangay where the respondent or any of the respondents actually reside, at the choice of the complainant. Letter C, sub-question. In the above example, suppose Mario is a resident of Barangay Poblacion Tublay, Benguet, and Johnny is a resident of Chilan, La Trinidad, Benguet. Barangays Poblacion, Tublay, and Chilan are adjacent each other. Mario files a complaint against Johnny in Barangay Chilan, where Johnny resides. The punong barangay of Chilan accepts the complaint. Is he right in accepting the complaint? Explain. This question is answered in Tabora versus Veloso and Agbayani versus Belen. The Lupon shall have no jurisdiction over disputes where the parties are not actual residents of the same city or municipality, except where the barangay in which they actually reside adjoin each other. In such a situation, where the Lupon is without jurisdiction of the controversy because the parties are not actual residents of the same city or municipality, or of adjoining barangays, the nature of the controversy is of no moment whether or not affecting real property or interest therein, located in the same city or municipality, and the principle is not at an altered by the proviso of Section 3 of PD 1508 governing venue, that disputes which involve real property or any interest therein shall be brought in the barangay where the real property or any part thereof is situated. In the case of Agbayani versus Belen, while it appears in the record that the parties reside in barangays of different cities or municipalities, the real property subject matter of the case are not, however, located in different barangays, but in one and the same barangay, that is Barangay Tubuan, Sual, Pangasinan. Based on these facts obtaining in this case, it is clear and clean that the present action is within the authority of the Lupon. Hence, the provision of PD 1508 should first be complied with before the complaint could be filed in court. Number 3. Martin was arrested by the police without a warrant of arrest in the act of committing a crime, now detained at the city jail of Baguio. If the offense he has committed is punishable by imprisonment of not exceeding 6 months, should he be brought to the barangay for mediation before filing the case in court? Explain. Under Supreme Court Administrative Circular 1493, it provides the following additional cases which do not require the mandatory conciliation or mediation before the Lupon. 1. Disputes where urgent legal action is necessary to prevent injustice from being committed or further continued, specifically the following. A. Criminal cases where accused is under police custody or detention. This is under Section 412, letter B, number 1. Where parties may go directly to court. The parties may go directly to court in the following instances. Number 1. Where the accused is under detention. A case for violation of Batas Pambansa, Bilang 22, was filed against Dante in the metropolitan Baguio City. After the court acquired jurisdiction over the person of the accused, how will the case be prosecuted? When will the case be set for arraignment and pre-trial or preliminary conference? B. When will the parties be referred for mediation before the PMC? Under Section 7 of the Rules and Summary Procedure, not later than 30 days after the last answer is filed, a preliminary conference shall be held. The rules in pre-trial in ordinary cases shall be applicable to the preliminary conference, unless inconsistent with the provision of this rule. The failure of the plaintiff to appear in the preliminary conference shall be a cause for the dismissal of this complaint. The defendant who appears in the absence of the plaintiff shall be entitled to judgment on his counterclaim in accordance with Section 6 hereof. All cross-claims shall be dismissed.